Good morning, everyone, and a warm welcome to this Birketts webinar on the Procurement Act 2023. I'm Claire Jones, and I am a legal director here in the public sector team at Birketts, and I am joined this morning by my colleague Mike Caution, who's the senior associate in our team. To let you know, a copy of the slides and a recording of the webinar will be available after the session. And before we get going, you will see that there is a box that allows you to ask questions. Please do feel free to send us any questions, and we will try to answer some of those at the end of the session if we have time remaining. If we don't, then do still put in the questions and we will try to respond to those after the session by email. So if you could do the next slide, please, and the next one. So the Procurement Act 2023 is one of a number of significant pieces of legislation that has been passed post-Brexit and which will affect the public sector, and some of those are on the screen. Of course, in today's session, we are going to be focusing on the Procurement Act. So the next slide, please. You'll see on this slide that we've set out what the government's aims are for this Act. And overarching that, the government is planning to publish the National Procurement Policy Statement. And what we're going to do today is we're going to go through these four themes or four aims of the government and see how those actually manifest themselves in the Act itself. So Mike is going to talk to you about the simpler and more flexible commercial system and tough action on underperforming suppliers. And I'm going to talk about transparency and new entrants and small businesses. But before that, if we could have the next slide, please. And before I hand over to Mike, we thought it'd be helpful just to have a look at what the Procurement Act itself says about the primary principles and objectives of the procurement regime. And we can see that this is set out in section 12 of the Act. And public authorities are going to have regard to the importance of delivering value for money, maximising public benefit and sharing information. They're going to have to treat suppliers the same unless the difference between the suppliers justifies the different treatment, and have regard to the fact that small and medium-sized enterprises may face particular barriers to participation and whether such barriers can be removed or reduced. So that's really the background in the Act to all the other provisions. So if I hand over to Mike, he's going to take you first through simpler and more flexible commercial system.
Well, good morning, everyone. So I'm going to go through the slide in terms of what's in terms of the more flexible commercial system, that, as you've seen there from the objectives from the government of what they're trying to achieve, and then how that flows essentially into the various procedures. So next slide, please. So we thought it helpful first to just list out the procedures that were available under the Procurement Act. Some of these obviously will look very familiar and some of them less so. In some cases there is just, for example, a change of name, whereas in other cases there's effectively a new procedure. And for the purpose of this seminar this morning, we're not going to talk about the open framework. And the reason for this is that effectively there needs to be more guidance yet about how this would be used in practice. And obviously, if you've got any questions or any suggestions how you see it might be working in the future, welcome to have a chat about it, because it is a very interesting way of approach with frameworks. But effectively, then you'll be seeing the other sort of procedures being very familiar, having lots of their kind of tendrils, if we can put it that way, in the procurement public contracts regulations to where we are now with the Procurement Act. A key theme of all procedures is that the contracting authority, you guys, have to consider what is proportionate means of awarding the public contract. So do you consider that before we go ahead and decide which procedure you're going to use? You're going to be looking at the nature, the complexity, and the cost of the contract when you're deciding which procedure to use. Next slide, please. So all of this comes under the first thing that you obviously may have heard as the Procurement Act comes through, is that effectively we are looking at MAT, that is most advantageous tender. This is a move from MEET, most economically advantageous tender. So what does that really mean? Well, I'll be honest, I'm keen to see how that will actually change from what we do already, because as you see, you'll be effectively still assessing in accordance with your assessment methodology, which you would have published as part of your ITT. And you would have also considered weighting, so the relative importance of criteria. And you've considered the requirements and what actual tender submission best meets the contracting authority's requirements. So this is our starting point. In section 19, that award of public contracts following competitive tendering, we'll come on to this in a bit, must fulfill these criteria. But we also see some discretionary and mandatory grounds for not allowing a tender to proceed or be awarded to. So firstly, just to flag at this stage, if a tender does not satisfy the conditions of participation, then it must be disregarded. And we'll come on to this a bit later when we look at excluded and excludable grounds. And we also see that we may disregard non-UK, non-treaty state suppliers where the tender is abnormally low, so that will obviously be quite familiar to everyone, or where we've reached a procedural requirement. Again, with a lot of this, there needs to be certainty with guidance. So there's a lot of grey area that remains in terms of what we say does not satisfy the conditions of participation. And when we talk about disregarding non-UK, non-treaty state suppliers, we're still in a world where effectively we are not going to discriminate effectively against member states. So when we think about this, think about it in terms of EU, think about it in terms of who we have free trade agreements. The Procurement Act does contain a list of all the relevant treaty state suppliers to have regard to. And just to consider the procedural requirements, this includes providing supplier information, although again, query, and this is one to look out for in the next few months, what this means in practice and what the levels of discretion, say, that a contracting authority can provide. Next slide, please. So procuring effectively, this takes us a bit of a step back, but effectively we need to comply with these grounds when we are procuring under a covered procurement. So effectively competitive award under section 20, direct award in special cases, which we'll come into in section 41, and direct award after switching procedures under section 43, and award under frameworks under section 45. Next slide, please. So first of all, we come to our open procedure. So starting with what we know, it is much like the open procedure under the public contracts regulations. It's a single stage process without restriction or down selection. The interesting thing that the Procurement Act offers is some clarity about when we can make changes to the procedure. And the key thing here in regards to the open procedure is that it must be before the deadline for submission for tenders. The terms of the procurement is widely defined. It includes associated documents, it includes what you put in the tender notice. So do be aware that if you're going to have an impact on the terms of procurement, if it's before the deadline, you must then extend. So if modifying the terms of procurement, we must consider revising our time limits in terms of when the timeline for tenders to provide submissions. This is under section 54 of the Procurement Act. And we must revise and republish the tender notice and associated documents. It's interesting to see when we have a look at section 54 that we have to have also regard when setting time limits, where relevant, the nature and complexity of the contract being awarded, and the importance of avoiding unnecessary delay. So again, this brings us back to the key objectives of what government is trying to achieve with the reforms under the Procurement Act. That our key objectives include value for money and integrity, and also transparency. So thinking about this in the context of when we need to extend our deadlines, we have something quite similar under section regulation 47 of the public contracts regulations in terms of extending time limits. And in that case, we looked at proportionality. So you'd often say, well, okay, we have a contract and we need contractors to look at this. So we would extend to a proportionate amount. And so effectively, we have very much the same under the Procurement Act. There's going to be a decision, a discretionary decision by the contracting authority to decide how long it needs to extend the timelines by. Next slide, please. So now we come on to the competitive flexible procedure. So effectively what I put out here is that we are bringing together existing procedures under the procurement and public contracts regulations into a single flexible procedure. So rather than having restrictive competitive procedure with negotiation, competitive dialogue, innovation partnership, we now have a single competitive procedure. And this again is going to be much like what you might be used to. So we have a multi-stage process with down selection. And again, we have the ability to modify the terms of the procurement, provided it's before the deadline for submitting a request to participate, or for the deadline for submitting the first and only tender. You can also modify the before the deadline for assessments if it is non-substantial. Again, much like under the open procedure, if you're modifying the terms of procurement, you will need to consider revising the time limits. Again, going back to our principles of procurement and allowing transparency and equal treatment. And you have to revise and republish the tender notice. And of course, they're the carve out for non-substantial. At that stage, presumably you would have down selected, and so therefore you're going to only notify the participating supplier. So how will this be used in practice? Well, that's an open question. Because I think that the issue will be between going out and saying, okay, we can have a competitive flexible procedure and therefore there aren't the same restrictions in terms of procedure and stages that we might have been used to and be familiar with, quite frankly. And then giving the discretion to the contracting authority to say, okay, this is what we need to do in order to achieve what we're going to award. Personally, I feel that it's going to be a case of reverting back to type. So the idea being that with the greater flexibility, it potentially is just going to be a lot more straightforward from both the contracting authority's perspective and also familiarity to the supplier's perspective, that you continue using procedures much like a competitive procedure with negotiation, competitive dialogue, or restrictive. However, obviously subject to guidance, I'd still encourage some more flexibility here, because effectively it all comes down to what is proportionate in the circumstances. So allowing the freedom to contracting authorities to procure in the way that's appropriate to the award. Next slide, please. So now we're coming on to direct award in special cases. And the key headline here is that if a direct award justification applies, you may award to a non-excluded supplier. So this sounds much like Regulation 32, as you may be familiar, and the justifications, the direct award justifications under Schedule 5 will also look very familiar. So, for example, we have artistic works. We also have exclusive rights for where no other reasonable alternative. We have technical reasons, and we also have where a change of supplier would receive incompatible goods. As part of the direct award, it's quite interesting to see that the Act says that you may carry out a selection process or take other such preliminary steps as you consider appropriate for awarding a contract. And this is particularly relevant when we think about excluded and excludable suppliers. So effectively what we'd be saying is you need to be checking at the stage whether or not they are a non-excluded supplier. So effectively, before the direct award, you've got to consider whether they're an excludable supplier and decide what selection process or other preliminary steps you consider appropriate. So it's not just a case of just going straight into a contract. There will need to be a level of due diligence in terms of ensuring that the supply is appropriate. I've also flagged here on this slide that you can also award to an excluded supplier where there is an overriding public interest. And the thing that will be most relevant for contracting authorities on overriding public interest will be where there is urgency, effectively, and that an award cannot be made within the necessary time frame. Again, it's something that we'll need to see guidance about what the suitable approach should be when enforcing this. Next slide, please. So now we come on to switching to direct award under Section 43 of the Procurement Act 2023. And this is much like the negotiated procedure without publication under Regulation 32(2)A. So firstly, we have an award to a supplier who's not excluded, provided the contracting authority has firstly invited suppliers to submit tenders to a competitive tendering procedure. And just in terms of terminology, competitive tendering procedure is both open and competitive flexible. Has not received any suitable tenders. So again, we come into this world where it's very similar to the Public Contracts Regulations 2015 in terms of what is suitable. And finally, that an award under Section 19 is not possible. So firstly, what is not suitable? So for example, it wouldn't meet any conditions of participation, or it was abnormally low, or it's from a non-UK or treaty state supplier. So we have a mix of discretionary and mandatory grounds. Further, it says that there's evidence of corruption or collusion. So the response to the direct award clearly needs to undertake this due diligence to make sure that the supplier is not excluded. Finally, it also materially breaches the procedural requirement in the tender notice or associated tender documents. So one might think of examples where there has been a competition failure, where no providers have provided a suitable tender. Question how that then works in the context of this new switching to direct award. So therefore, the local authority must take steps to obtain evidence and carry out a selection process to make sure the justification to rely on Section 43, especially if to confirm that the supplier is not excluded. So practically speaking, and TBC, what will that look like? Will it look like a selection questionnaire? Or will it look like something else? So finally, just to wrap up on that slide, so before the direct award, the contracting authority must consider whether the supplier is an excludable supplier, so discretionary, must consider whether the supplier submitted unsuitable tender in response, and decide what selection process or other preliminary steps as it considers appropriate. And I think just in terms of good governance that this is, and if we go back again to our objectives, this is a good idea for the contracting authority to have a good, clear decision-making process to demonstrate that the decision they've come to is objective and rational. Next slide, please. So awards under frameworks. Again, this will look very familiar to basic contracting authorities in terms of what can be provided for. So chats just to go over the circumstances of what contracting authorities may enter into a framework. Interestingly, we may only provide for without competition where it's a single supplier framework or where the framework sets out core terms of the public contract and the objective mechanism for selecting a supplier. There is certain information that has to be included in the description of the work, goods or services entitled toward the public contract. And these include effectively the price payable, the term of the framework, how the contracting authority intend to award call-offs under the framework. Just again, in terms of terminology, you'll see the Procurement Act talks about public contracts. It doesn't talk about call-offs. And finally, may not permit the award of a public contract to an excluded provider. And we see things again about the term of the framework. So again, we're limited to 4 years. However, the Procurement Act actually gives us some more flexibility in this regard. So we can actually extend the term of the procurement of the framework, where there are reasons for having a longer term. The contracting authority needs to set out these reasons in the tender notice. There are some nuances for defence and utilities frameworks. And then for me personally, the most interesting thing that comes from this and where we might see some further guidance, hopefully, will be that fees may be charged under the framework. And this is for contracts that are awarded to the supplier. So not just adjoining, it has to have been awarded to a supplier. So questions from there arise in terms of, well, who gets the fees? Will it be the framework, the contracting authority who established the framework? Will it be a framework provider? Will it be some other entity? So it will be interesting to see how this is then applied in practice, because obviously, where will the fee be then paid? Next slide, please. So just to go over then the selection process and the implied terms. So we come back to this principle of any conditions for participation on the framework must be proportionate, looking at the legal and technical capacity to perform the contract or the technical ability to perform the contract, including the supplier's qualifications, experience, and technical ability. We do have some non-discrimination grounds and equal treatment grounds. The suppliers cannot just be awarded a contract because they have a contract with the contracting authority. And we have something quite similar in terms of breaking the rules and specifications. And effectively, that means we don't have specifications that defined by brand. It always has equivalence, and the specification is geared towards functional performance. And again, when we look at the conditions of participation, the contracting authority needs to have regard to the nature and complexity of the cost of the public contract. So again, very much front-loading all the responsibility onto the contracting authority to really have pulled together a procurement strategy and decided how it's going to award in much detail than perhaps where we are now, where there is no such obligation. And finally, just to cover, there is an implied term that the contracting authority may exclude a supplier, that it excludes a supplier, or since the water framework has become an excludable supplier. So again, it will be interesting to see whether or not the frameworks explicitly set this out or rely on the implied term. This term cannot be amended. Next slide, please. Finally, we're looking at dynamic markets under section 35. So for those who will be familiar with dynamic purchasing systems, this is effectively the sort of rebranded new dynamic purchasing system under regulation 34. Again, we have the same kind of membership provisions that reflect the provisions of conditions of participation under frameworks. So specifications cannot be targeted towards brands. And again, we have to look at the nature, complexity, and cost of contracts to be awarded by reference to suppliers and membership of the market when having a think about those conditions of participation. What's particularly interesting is that there are rights to remove members under the dynamic market, where, for example, the contracting authority considers suppliers excluded from mandatory exclusion grounds, does not satisfy the conditions of membership, or has since become excludable. So the question then is, how does this actually happen? So from a practical perspective, ensuring that there are mechanisms within the dynamic market terms to ensure that the suppliers are providing this declaration regularly, or at least as regularly as commercially reasonable. And we also have, again, I put in bold because this is particularly interesting, once again, that fees may be charged. So again, we have the same questions about where does this fee go, how is this fee set out, and of course, what the supplier would think about that fee. And just to say, one thing that's particularly interesting is that because of the conditions, we're thinking about this in terms of the number of suppliers and the dynamic market. So potentially here, there's going to be a burden on the contracting authority to consider whether a supplier should be excluded. So making sure that contracting authorities are building this into the process to make sure they've considered what resource burden that there may be, and finally, how they can actually address that. So I'm now going to move back to Claire, who will now be talking about transparency. Thank you.
Thank you, Mike. I'm going to focus next on transparency. So next slide, please. And it won't be a surprise to any of you, I don't think, that in the Act, this largely manifests itself in the form of notices and publication throughout the life cycle of the contract. So if we have a look at the graphic there, the idea being that the notices and enhanced publication throughout that life cycle work together to form a transparent process. So if we have the next slide, please. So the requirements for notices and publication can be divided into different stages of your the life cycle. So we start all the way from planning to implementation and contract end, and there are notices and publication requirements at every stage. So what I thought we could do today is take you through effectively the life cycle of a typical competitive procurement and look at some of those requirements that you as a contracting authority will need to meet. So next slide, please. So when we're planning a procurement, for many of you, your procurement year will start with a pipeline notice. So this is a new type of notice, and you must publish a pipeline notice if you are going to be paying more than £100 million under relevant contracts during the coming financial year. And in your notice, you're going to have to provide specified information, which will be later set out in regulations, regarding contracts where the estimated value is more than £2 million. And in respect of that contract, you're going to be intending to publish a tender notice or a transparency notice during the coming year. And there are time periods for you to serve that notice. So once you've done that at the start of the year, if we go on to a specific procurement that you might want to carry out, the first notice that you might think about serving is a planned procurement notice under section 15. So you may publish one of these notices, so it's not mandatory. And you will serve that as almost like an early warning if you're going to be intending to publish a tender notice later on. So why might you do that? It could be to engage with the market early, or if you serve one of these notices, you can take advantage of a reduced tender period. So if you are serving your planned procurement notice within the window set out on the slide, then you can take advantage of the reduced tender periods in section 54, and you can reduce your period from sometimes 25 to 30 days down to 10. So that might be something that's worth doing. So if you have the next slide, please. The next thing you might want to think about is preliminary market engagement. Now, we're all familiar with this concept under the 2015 regs, but we have a provision under section 16 of the Act, which sets out various purposes that the various purposes for which you might want to serve one of these notices and engage in preliminary market engagement, such as identifying suppliers, identifying contract terms, working out what you need to put into your contract. The thing to note here is there is an express duty when carrying out preliminary market engagement for a contracting authority to take steps to ensure that suppliers participating in that pre-market engagement are not put at an unfair, that are not going to be taking part in the pre-market engagement, won't be put at an unfair disadvantage, and that competition is not distorted. Now, because that's an active duty, before going out to market, the authority is going to have to consider that point and work out whether the design of what they're going to do for their pre-market engagement will distort competition, and whether it will put anyone at an advantage if they participate in that. If you are going to be doing preliminary market engagement, then we now have a preliminary market engagement notice. So I've set out on the slide the details of that. So you must publish the notice before you publish a tender notice, or if you haven't done that, you need to provide reasons why you didn't in the tender notice. So we're not entirely sure at this stage what those reasons might be, which would be valid reasons for not publishing a notice. But I think under public law principles, your decision would need to be reasonable, and you're going to have regard to your section 16 duty regarding unfair advantage. In your preliminary market engagement notice, the notice will need to set out whether you have engaged in preliminary market engagement or whether you intend to do that. So it's either or, so you can serve your notice before or after. But query, if you serve your notice after you've already done the engagement, that will notify suppliers that may have wished to participate and didn't to the fact that this preliminary market engagement has gone on, and possibly alert them to any unfairness that has resulted from that. So I think that's one to watch to see how that pans out. So if we could have the next slide, please. So we've served our preliminary market engagement notice, and we have decided that we're going out to tender. So we're all familiar with tender notices, and you will be needing to publish one of those if you want to award a contract under section 19 and competitive procedure. With that, you're going to have to provide any associated tender documents in accordance with your tender notice. Now here there's an express duty again in the Act which specifies and sets out that you cannot invite suppliers to participate in a competitive tender procedure unless you as a contracting authority are satisfied that those documents contain sufficient information to allow suppliers to prepare a tender, that the requirements set out in your tender documents are sufficiently clear and specific, and that they do not break rules on technical specifications. So I think what this is saying really is that you're going to, and Mike alluded to this, really front load some of these procurements, because before you go out to tender, you are going to have to make sure that those tender documents are going to be sufficient, consider them, decide that they are sufficient, and then publish them. And so it might be that particularly if you're engaging in a market where you've not awarded a contract before, that pre-market engagement is going to be necessary up front to enable you to satisfy yourselves that you've got the right documents. I just noticed on the bottom of that slide that actually if you're doing a direct award, you're also going to have to publish transparency notices if you are going to be doing that. So we've published our tender notice. Next slide, please. We've got our ducks in a row. Hopefully, because we've done our pre-market engagement, we've thought about this process in our pipeline. All of our documents are correct and all of our specs are correct when we send them out. However, the Act then goes on to specify when you can modify the published documents. So that's found in section 31 as regards competitive tendering. So I've set this out in the slide that actually the Act is quite clear and it does give us some deadlines and some more guidance about when we can modify our tender documents. So if we have a look at section 31.1 there on the slide, if you are using an open procedure, then you can make changes to your documents before the deadline for submitting tenders. And if you're using a competitive flexible procedure, the deadline for a request to participate, or if you're not doing it that way, the deadline for submitting a first or only tender. So that is relatively restrictive. And it does go on to say that where you are going to be modifying your contract documents, you must consider revising applicable tender deadlines, which is set out in section 54. So you're going to have to actively consider that. And also revise and republish or provide the tender notice again, together with the associated tender documents. So I think what that's really saying is it is definitely going to be worth getting it right first time when publishing your tender pack. You do get almost a second go at it if you're using a competitive flexible procedure, because we have an additional provision there that says if modifications are not substantial, then you can make some modifications prior to the deadline for submitting tenders for assessment. So that's only in the competitive flexible procedure. Whether a modification is substantial or not is actually set out in the Act. So what that's focusing on really is if other people could have participated in the tender, if the modifications have been made earlier, or if anyone that's currently participating in the tender wouldn't be able to following the modifications. And that's all set out in detail in the Act. So that is slightly new. It has clarified the position, but what I think that is saying is that once those tenders have been submitted, the deadlines for modifications during the tender process have passed. So again, I think that really points to getting ducks in a row, getting organised and getting it right first time, really, when we're putting tender packs together. If we have the next slide, please. The next notice is, again, a new one. It's a procurement termination notice. So as always, if you go to procurement and you decide you don't want to progress, that's absolutely fine, but you are going to have to now serve a notice to say that that's happening, to notify the market that's all gone away. So if we have the next slide, please. So here we go, we've done our tender process, we've got things right, we're at the place where we're going to award our contract. So again, it's not something that we're unfamiliar with. Before entering a public contract, a contracting authority must now send and notify with a contract award notice. But before that, what you're going to have to do is provide an assessment summary to each supplier that submitted an assessed tender regarding the award of the contract. And then after that, you're going to have to publish a contract award notice to say that you intend to enter into a contract and include any information that's going to be set out in regulations. And I think you'll probably notice going through all these slides that we are waiting for a significant amount of information about practicalities to come in regulations, which will come over the coming months. So your contract award notice will now trigger off your standstill period. So you've got, generally speaking, 8 working days beginning on the day on which the contract award notice is published for your standstill period. Once that's over, after you've entered into your public contract, you must serve a contract details notice to state that the contract has been entered into, and again provide any other information specified in regulations, and there's a time period for doing that. So I think provided that you're organised or aware that this is going to happen and have your contract notices ready, it's just going to be a case of making sure that all the notices are served in the correct periods of time, and that you are attending the various duties that you need to throughout the process and documenting that. So for me, I think whilst it's this is a big focus on transparency, for you and our other clients, part of it's going to be the organisation around it and making sure that we're front loading our procurement sufficiently to make sure that we can comply with this. So if we have the next slide, please. So we now come on to implementation. So we've all breathed a sigh of relief. Procurement's over, we've awarded a contract, and the contractor is getting on with the job. Really, for contracts previously that were running well, you probably haven't looked at the contracts again until expiry, because there hasn't been any need to. So let's have a look at, during this implementation phase or the life of the actual contract, if there's anything new. The first thing we're going to have a look at is modifying public contracts, because this is something that comes across certainly my desk quite a lot, of authorities wanting to modify contracts during the life of the contract. It may be that because of the additional requirements imposed by this Act regarding making sure that all the documents are accurate at the start, that we might be modifying a bit less during the life of the contract, but we'll have to see how that plays out. But if you do, if going forward you are going to want to make changes, again, you're going to have to serve a notice. So if you want to change the terms of your contract during the life, you'll be serving a contract change notice. So this won't apply to every modification, and in there we do have this de minimis provision, which basically is saying that if the estimated value is 10% or less for goods and services and 15% or works, then that would be de minimis. But interestingly, where the modification increases or decreases the term of the contract by 10% or less, then that will be de minimis. So I think particularly where contracts that are going well are coming towards end of life, it's not going to be necessarily possible to forget about it and extend the contract term anymore, if that is something that happened previously. So I do think the 10% or less contract term is something to look out for. When you have served your contract change notice, again, there's going to be a standstill period of 8 working days within which people need to think about whether they want to challenge that, and after which you can enter into your contract changes. So if we could have the next slide, please. When we talk about modifications, what are they? What can we do? So again, it's not so dissimilar to what we've got now. So we've got permitted modifications, which is set out in Schedule 8 of the Act. And as always, if you can provide for modifications up front in your contract documents, then that's all going to be much more helpful going forward. You can make a modification if it's not a substantial modification. And again, here it's clear that an increase or decrease in the term of a contract by more than 10% of the maximum term is going to be substantial. So particularly with how long you want these contracts to last, you are going to have to think about that quite carefully, I think, at the outset. A substantial modification can't materially change the scope of the contract or materially change the economic balance of the contract. So those are concepts I think that we're all familiar with in the current regime. We've got below threshold modifications, which are also fine. And again, as we've said, that's a 10 or 15% increase or decrease in value, depending on whether you're having a services or works contract. And also those de minimis modifications can't materially change the scope of the contract and materially change the economic balance of the contract. What I would say is, because now, of course, you've got to publish a notice unless your modification's de minimis, then the market will be on notice more to changes in contracts, and there's more scope. There may be more scope then for people or contractors to start challenging some of these modifications. So it'd be interesting to see how that plays out going forward. So if we could have the next slide, please. So publication of modifications. So after you've modified your public contract, where there's a qualifying modification, you're going to have to publish a copy of the contract as modified or the modification. And that applies where you've published a contract change notice and the estimated value is going to be more than £5 million. So that's, for bigger contracts, that's going to be an additional requirement. So if you can do the next slide, please. So publication during the lifetime of your contract. So we've got some new things to think about here. So a public contract in any event with an estimated value of more than £5 million must be published. There are provisions actually in the Act that deal with confidential information, so that will be dealt with. But in the main, the contract's going to have to be published within specific time limits. You're also going to have to publish specified information, which I'm not quite sure what that is, about any payments of more than £30,000 made by the authority under a public contract. And looking at the time limits, it looks like that's going to be done quarterly. So where you're making payments more than £30,000 under a public contract, then you're going to have to report something quarterly about that. So I guess it's watch out for regulations that are going to deal with what you actually have to do. So next slide, please. You're going to have to publish information which again will be specified in regulations in relation to an assessment of the performance of a contractor against KPIs. And this looks like it's going to have to be done at least once in every 12-month period. So it'd be quite interesting to see what comes up in the regulations as to what information you're going to have to publish. And I do think this is probably in practice going to impact more those contracts which are in the drawer, which are working perfectly well, you don't need to look at. Obviously, if contracts are very big or problematic, you're looking at them and looking at KPIs in any event. So it'd be interesting to see how much of this information is going to have to be published. Again, breaches. Where a supplier has breached one of your contracts and that breach has resulted in termination, award of damages or a settlement agreement, then you're going to have to publish information about that to say that this particular provision of the Act applies and to give some information about the circumstances. And again, we expect to get more information about that in regulations. I think that's probably quite a helpful tool if you have suppliers which are being difficult, but again, it just means that you're going to have to actively manage some of these contracts, probably a little bit more than you have previously. Can we have the next slide, please? We've also got something called payment compliance notices. So specified information is going to have to be published in relation to obligations to make payments within 30 days. Now, those obligations are set out in section 68, and you can read those in your own copy of the Procurement Act, which I'm sure is probably going to be on everybody's desks for the next 6 months for some light reading. Those notices are going to be served if during your reporting period a payment has been made under a public contract or a sum is owed by the contracting authority and has become payable. So that actually could encompass quite a lot of information. So it'd be quite interesting to see what actually is going to be required on that. and a reporting period for this purpose is going to be 6 monthly. So the reporting periods for different provisions don't necessarily tie up. So I think care is going to have to be taken when the regulations come out to see what publications regulations you're going to have to comply with. Contract termination notices. Now, this is another interesting thing, which is probably quite helpful for suppliers if they want to know what contracts might be coming up in the pipeline. So again, you're going to have to serve a notice that your contract has been terminated and any other information specified in regulations. Now, a termination in this context means a contract has been discharged. So that could be if you have a project-specific contract. Often, construction type contracts might have that. Once the contractor's done his work and his obligations have been discharged, then a notice will need to be served. And again, expiry is a termination. So I think, it goes back to the practical application of the Act for you is going to be checking and making sure you're aware when all your contracts do expire, and being ready to serve the appropriate notices at the appropriate time. And the time period, again, is set out on the slide and is before the end of the period of 30 days, beginning with the day on which a public contract is terminated. I do think serving the notice might be helpful in the sense that it will focus the mind on the next set of notices and procurements that you're going to have to deal with when you re-procure a contract. Can we have the next slide, please? This is my last slide, and it's just a really quick one actually on below threshold contracts. Just to say that for regulated below threshold contracts, notices are going to have to be served in relation to those. So just to be aware. Although I would say that whilst all the notices that we've been talking about in relation to competitive procedures may be subject to civil proceedings, which means that contractors can bring claims in the court if they don't think that the authority's done what it should, that doesn't apply to below threshold contracts. I also think, as a last point, to flag section 105 of the new Procurement Act, which does say that if notices have not been served, and it means that a contractor then is not entitled to a pre-contract remedy through the courts, then the court has the power to set that contract aside. So that's quite interesting, and it does show that I think the notices that are being required, the government is treating quite seriously, because actually it's set out there in the remedies. So I know that I've gone on for a little while, it's quite a lot to say, and we've got 10 minutes, but I'm going to pass over to Mike now to talk to you a little bit about underperforming suppliers.
Thanks very much for that, Claire, and a very helpful run through of all the notices. Again, coming back to those kind of objectives of what we're trying to achieve when we competitively procure as a contracting authority. So I'm now going to talk about unacceptable risk and underperforming suppliers, and there's a few things I'll draw your attention to. So I'll cover excluded and excludable suppliers, and we'll also talk about demand list. Being very conscious of time, unfortunately, we might have to go quite quickly over a few of these slides, but of course, if you have any questions, feel free to put them in the chat. We'll come back to us later after the session. So next slide, please. So the starting point for excluding suppliers is under section 26 to 27. In assessing competitive tender procedures, so again, we come back to open or competitive flexible, must disregard excluded suppliers before assessing which tender best satisfies the award criteria, and must consider whether the supplier is excludable and may disregard that tender. Just a note as well, in terms of the carve-out specifically for competitive flexible procedure, it's before permitting a supplier to participate or progress in part of, must determine whether the supplier is excluded or excludable. So the key question that flows from all of this is, well, what does it actually mean to be excluded or an excludable supplier? Next slide, please. So hopefully we set out on this slide quite clearly where your kind of key grounds are, where you need to go when you're considering this. So starting off then with the excluded supplier, mandatory exclusion applies, which is to be found under Schedule 6 of the Procurement Act in relation to the supplier or an associated person. And this concept of associated person will come up a lot, but just for the purpose of this webinar, consider it as part of the supplier's supply chain. And then secondly, as part of the excluded provision, the circumstances give rise to the application of the exclusion ground are continuing or likely to occur again. And then lastly, or the supplier or the associated person is on the debarment list. So that is the ground. So having a look at Schedule 6, and it'll look quite familiar to what you're used to under the selection questionnaire in terms of what is a mandatory and what is a discretionary ground. So then we look at excludable, which is our discretionary grounds. So this time you're looking at Schedule 7, and again you're looking at the supplier or the associated person, so part of the supplier's supply chain. And again, the circumstances give rise to the application of the exclusion are continuing or likely to occur again, or the suppliers or the associated person is on a debarment list. So what does that actually mean in terms of what the exclusion grounds are continuing or likely to occur again? Well, this can look like whether or not the supplier is paying any compensation, whether the supplier is undertaking certain inter-organizational grounds, such as they've removed certain management or key personnel, or that they have put in place certain measures that have been assured by the contracting authority, or that they've provided any other evidence, or that time has elapsed since the circumstances occurred. When thinking about excluded or excludable suppliers, the contracting authority must give the supplier reasonable opportunity to make representations and provide evidence. So there's some questions here about how practically, again, this happens, as Claire and I have been speaking to throughout this webinar, how this actually works in practice. So when you're running procurement, it is incumbent on you as the contracting authority to give the reasonable opportunity to the supplier in order to make representations when you're considering that they're going to be excluded or excludable, because there are significant consequences for them. But what does this actually mean? What kind of reasonable opportunity should we take into account? And what evidence do you need? Next slide, please. So, because consequently, we have the evidence that we're looking at. Sorry, apologies. Just going a bit quick because I'm conscious of time. So they're taking it seriously, as we've discussed. And I think we've just discussed that, so we can move on to the next slide, please. Of course, these are available at your leisure, so you can have a look at these. So then, of course, we go into debarment. So we're looking at the new feature of the public contract regulations. And this is where you have excluded the supplier. You need to give notice to the relevant appropriate authority. So in practice, that will probably be the Cabinet Office, when beginning on the day that the tender was disregarded, 30 days. And as part of this, as you can probably expect, and as I guess, this is going to be a much one of the new battlegrounds. So we've always considered that evaluation and giving back feedback to suppliers is one of the key battlegrounds in procurement. I think this is going to be the new battleground. So it's very important that there is a nice, clear evidence trail for the contracting authority to demonstrate why they've come to a particular view. And I'm just going to go a little bit quicker, but effectively there is a duty on the contracting authority to provide information to the Cabinet Office. So you may receive a notice that says, please provide us with these documents, or give other such assistance as is reasonable. There may also be a time frame in which to comply with the notice. And you will also need to update the central government in terms of any proceedings when they've commenced and when they've been determined, i.e. their outcomes. And I guess the key question here is, how do we actually find out that the supplier is on the debarment list, for example? These should be forthcoming in guidance and regulations, but it's yet to be seen. And then next slide, please. So conscious of time, just to quickly go over the key performance indicators, that where you have a contract over 5 million, you will need to publish and include a minimum of 3 KPIs, key performance indicators. You might think, however, you don't need to do that on all circumstances. So you do have an element of discretion whether or not to include it. As part of this, as Claire set out, there is also a notification, a public notification once a year, and on termination in terms of how the key supplier has performed under the key performance indicators. But the question remains about what happens if the key performance indicators change during the life of the contract. So there's a greater emphasis to get the KPIs right at the first instance and ensure that the supplier understands what is required from them. I'm going to switch over now to Claire, who will just be talking about the last part about SMEs. Thank you.
Hey, I think it's just it shouldn't take too long, but it'd be interesting to see in the Act what we've got for new entrants, small businesses and social enterprises, and see how the government's plans have manifested themselves in the Act. So if we could have the next slide, please. So we've got our general objectives, which we talked about right at the start, about having regard to these small and medium-sized enterprises. And there's also a new duty in section 86 for regulated below threshold contracts, where there's an active duty to consider small and medium-sized enterprises for those below threshold contracts. Interestingly though, neither of these sections is actually going to be enforceable in civil proceedings in Part 9 of the Act. So presumably the regulator will have a look at that if there are any issues, but the contractors won't be able to bring claims for breaches of either of those regulations. So next slide, please. So new entrants, is there anything in the Act for them? Well, we have some general bits that might help. So section 21, which is Mike talked about earlier, is about selecting a proportionate procedure as a means of awarding a public contract, having regard to the nature, complexity and cost of the contract. So proportionate consideration might be that the procedure is simple and is more helpful for SMEs and new entrants to participate. So that might help. Section 22, where we look at competitive award conditions of participation. Again, we have this proportionality requirement, which might help some SMEs and new entrants. Expressly stated in the Act is the point that as a contracting authority, you can't require audited accounts as part of your conditions of participation for a competitive award unless suppliers are required to have them, which might help new entrants that clearly don't have accounts. And also, it's very similar to what we've got already, but a supplier can be treated as satisfying a condition of participation to the extent that a supplier associated with the supplier satisfies the conditions instead. So the idea here is that you could do a joint bid and satisfy the conditions jointly. You could have a subcontract to a supplier that meets the conditions or a guarantee, for example, from a parent company, which might help a new entrant that is a subsidiary. So none of those are necessarily new concepts, but they are in the Act and they might help with the government's desire to assist SMEs and new entrants. So next slide, please. We also have a concept in the Act as reserved contracts. So it would be interesting to see how often these are used in practice. So you can reserve contracts to supported employment providers when using the competitive flexible procedure. And these supported employment providers are organisations that operate wholly or partly for the purpose of providing employment or employment related to support to disabled or disadvantaged individuals. And in those cases, 30% of the workforce must be represented by those disadvantaged or disabled individuals. I haven't been able to find any definitions of actually what disabled or disadvantaged means, but the concept is there. And the guidance notes at the back of the Act state that this definition intends to capture employment programmes to support the continued collaboration among organisations. So next slide, please. Again, reserved contracts, there's quite some detailed provisions in the Act about reserving contracts to public service mutuals, and I've set up the definitions there on the slide just to help you, and of course the wording is in the Act. How much this will be used in practice, again, I don't know, but that provision has been included if you want to reserve contracts to public service mutuals. So next slide, please. So we bring Mike back as well, just for this last part, just to say as an overview, we've had a look at these themes and the government's aims and objectives. And I certainly think for me, one of the key takeaways is going to be the planning, considering your relevant duties, getting ducks in a row at an earlier stage, being more organised and be ready. And then I think the rest of the procurement will run relatively smoothly once those ducks are in the row at the start. I don't know about you, Mike, what your take home is from all of this.
Yeah, absolutely. I think when we're thinking about the change from MAC to MEET, and we're also thinking about our principles and objectives of having integrity and value for money. I mean, side question, what does value for money actually mean? Because it could mean different things to different people when you ask. I think it's going to be quite interesting to see what actually will change in terms of the procedures and how procedures are conducted, notwithstanding there's going to presumably evidently is going to be an increased resource burden on contracting authorities to comply with the various provisions as Claire has very clearly set out. So I think planning is key. I would definitely absolutely agree, especially when it comes to KPIs as well.
Yeah, so if we just go to the last slide, I had a feeling this would happen, that we wouldn't have time for questions. There's so much to go through on the Procurement Act, and we really wanted to give as much information as we could to you and share our thoughts with you during the seminar. So on the slide there is our contact details. Mike and myself are very, very happy to answer your questions. So please do get in touch if anything sort of springs to mind, or any thoughts you want to discuss with us, then obviously do drop us a line. And as I said at the start, a recording of this, a copy of the slides will be pinged out to you after the seminar. So it's been lovely to meet you, and I'm going to sign off. So goodbye. I hope you enjoy the rest of your day.
Thank you and goodbye.